All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have only one case on the docket today, and that is Apex Roofing versus USA. Are you ready to proceed?
Yes, Your Honor. Good afternoon, Your Honors. My name is Margaret Garner from Catranis, Wald, and Garner, and along with my co-counsel, Mr. Richard Asfar of Almazan Law, I am here representing the appellant, Apex Roofing and Restoration, LLC, as the assignee of Monica Williams, and I would like to reserve 4 minutes for rebuttal, please. Normally, I would begin by talking about what the case is about, but given some of the contents of the answer brief, I think I need to start by saying this. This is not a case where you're being asked to decide if the trial court correctly determined that an assignment of benefits was non-compliant with 6277152. We conceded that point in our initial brief, and for purposes of this appeal, we are conceding that it was non-compliant based on case law that was released long after the assignment of benefits was signed, and most of the pertinent
From this
facts.
court?
I'm sorry?
From this court?
No, Your Honor. It was from a court, the fourth DCA. There were several cases. However, the trial court relied on those cases in dismissing, and they were also raised in the response to our motion for
But
rehearing.
couldn't you have argued in your briefing that the trial court was bound by it because we hadn't ruled on it, but we're free to consider it anew? Maybe the other DCAs were wrong.
I mean, Your Honor, let me put it this way. If you want to go back and re-examine, I'm happy to have that conversation. I'd be more than happy to do that. Our issue that we presented here was more for purposes of the reality of the situation that assignments exist in today's version of law, which is that there are no more of them, and my presumption that the appellate courts might not want to take the time to rule on issues that have now been sort of foreclosed by the legislation, saying that assignment of benefits for property damage moving forward are not going to be valid regardless of what they look like. But if the court wants to talk about whether or not the assignment was valid based on how it was submitted, we can have that conversation. Our point is more just that it does not matter for purposes of a case that was not brought as a breach of contract, which is what 627.7152 references.
Well, can I ask you that, though? In the amended complaint,
Yes, sir.
And I think it's paragraph 4, I have it here somewhere, I can find the exact paragraph. It's alleged that Apex is suing as assignee there in the amended complaint. So you're now trying to say, well, it doesn't matter that we're an assignee, but those were the allegations before the trial court, right?
Yes, Your Honor. It's not that it does not matter if we had standing pursuant to 7152 with a valid assignment that complied with that statute, because first 7152 is about breach of contracts. 624.155 is the statute that defines the cause of action that appellants brought at the trial court below, which is for bad faith seeking extra contractual remedies, by very definition taking it outside of the application of 627.7152. But moreover, this is really a case about the common law doctrines, to your point about what is binding on the courts and where it's issued. Common law continues to be the law unless the legislature expressly precludes it from applying to statutes that are created in derogation of common law. The parties very much agree that the statute that we based our complaint and amended complaint on, 624.155, is a statute created in derogation of common law because the right to a bad faith cause of action as a first party and even as a third party in property damage contexts did not exist at common law. So because of that, the common law principles of waiver and equitable estoppel and ratification continue to apply absent legislative intent expressed in their clear language in the statute, that those principles were not meant to apply. And obviously we have decades of Florida Supreme Court interpretation of our laws and our statutes expressly saying that any right that arises either from the Florida Constitution or a statute may be waived if not exercised.
So you're trying to bring then a third-party bad faith action? right? It's not first party in that you're not saying you're the insured, it's a third party bad
We-
faith.
Your Honor, we brought it as the insured because we had been treated as valid assignees by USAA throughout the entire process, including but not limited to their response to the civil remedy notice that was filed. This is not an issue of a carrier staying silent when they know that they have an issue that could give rise to an affirmative defense if they were to be sued in relation to the transaction. This is a case where affirmative representations were made, not just to Apex, but to their own insured, and then to the Office of Insurance Regulation when they responded to the civil remedy notice. Our reliance on Bay specifically is in part because the Fourth DCA, this court's sister circuit, examined a case where, frankly, USAA is familiar with the arguments because my opposing counsel's law firm was the appellate counsel that argued Bay before the Fourth on behalf of USAA, who's the same carrier we have here today. And the Fourth's point, when they reached their holding in Bay, which has since been brought up and expanded, most recently in Bailey, which I did a notice of filing supplemental authority with this court last week. Their point was that the whole purpose of the bad faith statute is to protect the consumers. It is to prohibit and attempt to dissuade carriers from engaging in bad faith conduct, and to encourage them when they're put on notice that there may be a problem with the way that they're handling a claim of what they need to do.
So basically, though, your argument is you didn't comply with the assignment of benefits statute as it existed at the time, but because USAA waived or is a stop from arguing to the contrary, you are the assignee.
Yes, Your Honor. In part because, and frankly, especially because of what happened after the CRN was filed, but even before they responded thereto.
But I mean, this is sort of an interesting case on a couple levels, but one is that the USAA is making the argument that, well, the trial court never got to the waiver and estoppel arguments. The trial court's ruling just went to whether or not you had a valid assignment of benefits.
And Your Honor, to that I would say first that if you look at the transcript, it becomes somewhat apparent that the trial court during the hearing especially was not persuaded by the application of waiver and estoppel because she felt, as was quoted in the order, both in the original order and the order denying our motion for rehearing, that the noncompliance with 752 rendered the assignment illegal, and illegal contracts where the purpose of the contract
But my
itself is
question
illegal.
is, don't we have to rule on the assignment of benefits question? And given that the county court never even passed go and collected the $200 and went to the next question? At least that's USAA's argument is, look, we should exercise judicial humility, which of course we always strive to do, and that because the trial court never got to that issue, we can't get or should not get to it either. So what's your response to that?
Well, first, Your Honor, you have a de novo review. The issues were well preserved and argued by both sides, both in briefing and orally at the hearing. And beyond just that, there is an inherent ruling on the application of those based on the trial court's oral pronouncements during the hearing and her reference to in the order on our denying our motion for rehearing that our waiver and estoppel arguments were unavailing, and tying that to her conclusion about the assignment being illegal. And that if it is illegal, I will give the trial court this. If a contract has an illegal purpose, then the waiver of that illegality will not withstand scrutiny in the courts of this state.
Three other DCAs have held that if the assignment of benefits statute is violated, the contract is void. Not just voidable, but void, which is basically the same as an illegal contract. It can't be ratified. There's no estoppel. If I contract with you to buy 50 pounds of cocaine, it doesn't matter that I gave you $20,000, in good faith money. That contract's illegal. So isn't it the same thing? If we agree with our sister DCAs that it is void if it violates that, how do you get around that?
Well, Your Honor, first, to Judge Tenenbaum's point, this court has not ruled on the issue of the validity of an assignment and how that would translate into whether we are inserting, because the void language, it was not in the statute at the time that this assignment was executed, nor was it in effect at the time the CRN was served. It was invalid and unenforceable.
Well, and that's what the other DCAs have all analyzed in determining that invalid and unenforceable means the same thing as void.
Yes, Your Honor, but first, void does not mean illegal, and neither does illegal mean void. Illegality is defined and has been repeatedly defined by the courts of this state as arising when the purpose of a contract is contrary to law. That simply cannot apply as to illegality in a situation where there was at the time a statute in effect that specifically authorized using assignments of benefits in certain circumstances. So that was, the purpose of the contract was to assign the benefits, and that purpose was authorized expressly by 627.7152. But beyond just that, Your Honor, it's also, and this goes back to, this is not a breach of contract action, and it never was. There are two contracts at
As you
issue.
get close to 5 minutes, Madam Clerk, please allocate an additional 5 minutes per side. I may have mistakenly assigned this case only 15 minutes per side. I thought I had assigned it for 20. Thank you.
Thank you, Your Honor. The other issue that we have is there's not just one contract, the assignment at issue in the allegations in this specific complaint with regards to the bad faith conduct. There are two. The insurance policy, given that appraisal was undertaken in this case, because, and a carrier under Florida law is permitted to have language in their policy that provides even greater benefits than the law alone would provide. They just simply may not provide fewer benefits than the minimum required by Florida law. Their policy defines the appraisal process as a right available only to the insured, the named insured, and, quote, any assignees. So when Apex invoked appraisal, and by USAA's own admission, it was done pursuant to the terms of the policy, they were making us assignees pursuant to the terms of the policy, whether or not our compliance with 627.7152 was ultimately determined.
And that's an estoppel argument, right?
Yes.
That you're making. But that's different than your argument that the bad faith statute applies to any person, and Apex is any person because you're supposedly harmed by USAA's actions, right?
Well, Your Honor, to answer that, I would posit a hypothetical. Had USAA responded to the CRN that was filed, saying, instead of what they said, which is, this is defective for a single reason, and that is because we do not think that you included sufficient allegations to substantiate bad faith conduct, because that's the opening line of their response, and they say nothing about the assignment. Had they instead responded saying that, and additionally alleging, we also do not believe that your assignment complies with 627.7152, and therefore that you lack standing to file the CRN, Apex could have then gone to the insured and said, listen, if we're not an assignee, we can't invoke appraisal, we can't file suit, and the CRN may be meaningless. And then Monica Williams could have filed a CRN on her own, invoked appraisal on her own, obtained a public adjuster, obtained an attorney. Her rights were foreclosed to do anything additional on her claim because she too was relying on Apex being a valid assignee at that point because her carrier had represented to her that they were. Apex built this roof accepting the ACV payment of roughly a third of what the appraisal award ultimately said was actually owed.
In fact, isn't she still on the hook for the balance of what's owed?
If the assignment is invalid, then the appraisal award necessarily becomes invalid and potentially illegal. And USAA has essentially issued a gratuitous payment to a third party not pursuant to the terms of its policy, because if their argument is to be believed, they had no right to go to appraisal with Apex any more than Apex had a right to go to appraisal with USAA.
Well, does Apex still have a right to go, like if it is short, let's say $15,000 on the roof that it put in for the homeowner, does it still have the right to go after the homeowner for the balance?
Yes, Your Honor, because pursuant to 627.7152, once an assignment is rendered invalid or found to be invalid by any court of this state, then the preclusion against the assignee suing the insured for the balance that the carrier failed to pay is reactivated. The preclusion against an assignee having rights against the insured directly is premised upon because they have an assignment and therefore they have the right to collect the amount that's owed from the carrier.
So it's basically a windfall to the insurance company.
Correct. Especially because it's now been more than 3 years, so we're past the point where Ms. Williams could now turn around and ask for more money because she feels the claim was improperly handled.
So going back to my initial question.
Yes, Your Honor.
I mean, this is an order dismissing the complaint.
Yes, Your Honor.
So it seems like we should be talking just about was there some sort of facial basis for, some cause of action, arguably, that was stated in the complaint?
I agree.
And it seems like there's a lot of fact issues, not only on, I don't know anything that actually happened in this case, based on the record, which is just the complaint and the motion to dismiss.
I
Not
agree,
even
Your
the
Honor.
motion to dismiss, just the complaint. The allegations we have to take as true. That's the de novo review, I'm assuming.
Yes, Your
And
Honor.
we should be reviewing de novo just the question whether there was some basis, factual basis alleged, colorable, that you could move forward in court.
I agree, Your
Is that
Honor.
right?
Yes, Your Honor, I absolutely agree, especially,
So even this is a question I'm going to ask both sides. If the estimate, the pages 3 and 4 of Exhibit A, the composite Exhibit A, if that had a date of July 20th, would we be here today?
No, Your
Do you
Honor.
think?
no, Your Honor, based on the case law, no. And to
Well,
your
not just based on
point-
the case law, just based on, just on the face of it.
I agree.
Could they be arguing on a motion to dismiss that the estimate wasn't part of the AOB?
No, Your Honor. And to your point, had USAA said when they received the assignment on July 21st, the day after it was executed, had USAA responded to that saying, this is not a valid assignment, the estimate does not appear to be included in the assignment, and the insured did not sign it and see it, Apex by that point had not bought any supplies. They were still within the cancellation period. Apex could have turned around, gone back to Ms. Williams and said, we just want to make sure you have seen this. We're going to give you, it's the exact same document we gave you before. All we have done is now put on the back a handwritten thing that says, please see attached estimate incorporated herein, as if, incorporated herein is the attachment.
Well, based on the
dated the day
complaint-
before, and then it would have satisfied the only problem that they raised with it, because
But-
it would then be included and signed by the insured the next
But just
day.
taking the complaint on its face,
Yes,
the
ma'am.
allegations aren't even as detailed as the initial brief makes it seem. The initial brief breaks it out as there are two separate communications, and the estimate went to the insurance company. That doesn't appear even in the complaint. All the complaint says is that we have this AOB, it's composite Exhibit A, and it's 4 pages. Or 3 pages, the AOB plus the estimate.
Yes, Your Honor.
Two different dates. But it is possible, factually, we don't know, but it's factually possible that those are two writings that together evidence one contract, right?
Yes, Your Honor.
And so other than the other DCAs saying without any analysis that I could find, just saying it, that it all has to be on the same day, and I don't see that in the statute, it's conceivable that you have two different writings that evidence together one contract, which we won't know without any depositions, testimony from the parties.
I agree.
Which is what a lawsuit is supposed to be about.
Correct,
You
Your
do
Honor.
discovery, maybe you win, maybe you lose, maybe you lose on summary judgment, but that's not where we are. So this whole
I do
issue
want to
is,
note you're down to 3 minutes on your rebuttal.
and I'll stop talking in a second. So so this is all just
Thank you, Your
focuses on what could you have proven had you been able to go forward.
Yes, Your Honor, which is part of why one of the sort of third point is that one of the things USAA concedes and actually references multiple times in their answer brief, they keep referencing that there was no evidence of estoppel or waiver. Well, of course there wasn't. We were at a motion to dismiss, but the reason they say that is because waiver and estoppel and ratification are all typically issues of fact that we should be remanded for an opportunity to expand on through the discovery process and address at a motion for summary judgment. And I will yield. Thank you, Your Honors.
The clock says 15.
Yes, it should say 20.
Sorry.
Thank you. And you can pull that microphone towards yourself if you like. Thank you.
Good afternoon, Lara Edelstein on behalf of the Appellee USAA. Your Honors, you completely understand the fact that this is a simple dispute over the cost of a roof replacement, and the amended complaint was properly dismissed because the assignment by which the plaintiff brought the action was invalid and unenforceable. Section 627.7152 does apply here. I know that the appellant wants to ignore the fact that they had an assignment, and they've conceded that their assignment is, in fact, invalid and unenforceable. But I know that you're concerned about whether or not the fourth DCA cases apply here, and there are other cases. The two fourth DCA cases, the plaintiff or the appellant was Kidwell Group. And in those cases, the district court found that because the estimate was not executed or not entered into at the same time as the assignment of benefits, it was an invalid assignment.
Yeah, and I looked through those cases. Can you tell me which statutory provision they were, that they actually used to reach that conclusion? Because I can't find it in the statute.
There is no statutory requirement that it be executed on the same day. Now, having said that, with all due respect to our sister courts, we don't necessarily agree, or just speaking for myself with that analysis. But the strange posture here is that appellants aren't arguing that they had a valid contract. I'm not sure why, but they don't argue that. So instead they're relying on estoppel and waiver. So my question to you, which is a friendly question, is are they barred and precluded from arguing, and is this court precluded from considering whether it could have been in fact a valid contract?
Well, I do think that the court, as having de novo review, has the ability to look at the assignment of benefits that was attached to the amended complaint. Again, that is exactly how the plaintiff chose to bring this action and chose to file the CRN, in fact. The statute was enacted, the purpose behind it was to make sure that the insured knew exactly what it was that they were getting. There were too many instances where AOB companies were not providing estimates to the insureds, and then they'd submit something separate to the insurance company. And so in any case, this is to safeguard the insureds as well as the insurance company so that everybody's on the same page.
Right, I don't think the argument here is that the insured did not see the estimate, is it? I mean, the estimate was provided, I thought, the next day. Maybe it was 2 days. I thought it was 1 day, but
The estimate is, it says date entered in their computer system on the day after the assignment.
there's no affidavit from the insured that I never saw this estimate. I just signed the assignment, and I just left it up to them for how much to charge.
That's correct, but if the insured signed the assignment on July 20th, but the estimate wasn't even created because it was entered into their computer system the next day, then it's obvious that at the time that the assignment was entered into by the insured, the estimate had not yet been created. She
But an
hadn't
So
seen
we
it.
don't know if, I'm sorry.
It's okay.
We don't know if the the Apex didn't provide that estimate to the insured also the same day, right? And that the insured agreed that that was a reasonable price.
Or even the
Well-
next day, and they had a conversation, hey, sign this AOB today. We're going to give you the estimate tomorrow. If you're not fine with it, you see the big, giant, all caps letters that say you have a bunch of time to withdraw from this if you don't like it. How do we know that that conversation didn't happen? And how do we know if that did happen? Why aren't those two writings together evidence of one AOB?
Well, we don't know that any of those things happened, and that's because we're
Well, you didn't give them a chance.
Well, we're looking at the face of the complaint and the face of the assignment that was attached to the complaint, and as well as the estimate that went along with it, that was attached to it, but
Which they allege is one AOB. That's C Exhibit A, and it's all the pages. It's the AOB plus the estimate.
But
So
it
they've
wasn't,
alleged that it's one contract.
they can allege whatever they want, but it was dated the following day. And it's not as if it was created and then later given to her the next day. It wasn't even entered in their computer. If you look at the
Let's assume
page.
for the sake of argument that you're right, to go down a different road, and that it didn't comply with, where it's not a contract. It's two separate contracts. I guess that's essentially what the underlying rationale is here, that you really did not have an assignment, because you didn't have a meeting of the minds regarding the estimate. Assume that's true. But you don't deny, or in the brief, you dealt with Apex and the insured for quite some time on the basis that there was a valid assignment, correct?
The carrier adjusted the claim and worked with Apex, but they didn't make any affirmative allegations or representations that there was a valid
I
assignment of benefits.
understand, but parties went to arbitration, parties exchanged information. You know, how long did it take before USAA told the insured, I assume, and Apex, hey, we got you. We found out now the estimate's a day or two late, so we're not paying anything towards that estimate. How long did that take?
It wasn't during the pre-suit adjusting of the claim. It was in the motion to dismiss, because the motion to dismiss was based on standing.
I understand. How long did it take the insurance company, USAA, to tell the insured and/or Apex, I see here your estimate's a day late, and even though we've been adjusting this claim, going to arbitration, we now say you have no standing?
So the assignment of benefits was submitted prior to the suit on July 20th of 2020. The lawsuit wasn't filed until June 30th of 2022, and then we thereafter filed the motion to dismiss.
So why isn't there a fact question of estoppel or waiver that the trial court, that needs to go back to the trial court?
Because USAA took no actions to lull Apex into any.
Well, that's a fact question, isn't it? I mean, whether somebody did some action or didn't. They say that they've got some allegations. I don't know that they say specifically estoppel or waiver, but they do talk about USAA's conduct in adjusting the claim in their amended complaint. So why couldn't, even if the amended complaint is still lacking, why couldn't they go back and make specific allegations on this date this, on that date that? We would have done things like counsel said differently had USAA only at the start said the AOB was invalid.
So the actions that were taken don't constitute anything affirmative. So I'll tell you what the timeline is. USAA received the AOB and the written estimate July 20th and July 21st. USAA did nothing at that point except ask for supporting documentation, and Apex never provided it to them. Pursuant to USAA's independent adjuster who created an estimate, USAA approved a roof replacement in the amount of approximately just under $18,000. And so they went ahead and they issued the ACV check for just under.
To Apex, right? Apex.
To Apex. Now, they were entitled to issue the check to Apex because included in that assignment of benefits was also a direction to pay. And so they were able to issue payment under that direction to pay, which is not governed by any statute. And so they issued that ACV check, and then nothing happened from August 4th until February 18th of 2021, when Apex submitted the certificate of completion of the roof. So Apex underwent installing the roof without having provided any documentation to USAA, which they had requested, and did so at their own peril because it wasn't up to USAA to tell Apex that they didn't have a valid.
Those all seem like fact questions to me, though. I think your best argument, Judge Tannenbaum made the argument for their side, I think your best argument is because the assignment of benefits is void, then that can't be ratified through estoppel or waiver. What would you say to that argument?
Well, I think that the issue of standing is.
Well, that is your argument.
I'm sorry?
That is your argument. That the
Well, right,
contract
but
was void
standing.
The contract was void and unenforceable. And I'm not asking you to concede bad conduct, but as Judge Bilbrey knows, if it's void and unenforceable, it doesn't matter what USAA did. I appreciate your timeline, by the way, it's helpful. I guess in February, the $18,000 check was paid, and then in February, Apex came back and said, well, actually, the cost is 30 or, something more. And so But logically, your argument has to be, I think, and it is, that it does not matter whether we engaged in conduct that might be considered waiver or estoppel, because you had a void and unenforceable contract from the very beginning.
Absolutely.
Judge Bilbrey's hypothetical, we paid you the $20,000 for the 50 pounds of cocaine, but we're not going to pay you the other $30,000 because the contract's void and unenforceable. And that's strictly hypothetical. But logically, that's the argument, right?
Well, right. I mean, basically.
Because it has to be, because this timeline you're referring to, which it is very helpful, and I appreciate that, but as my colleague said, those are obviously all factual questions. So if those are factual questions, they can't be decided on a motion to dismiss. So the argument has to be crystallized as, this contract is void and unenforceable, and nothing USAA did could revive it, make it lawful. And just by the way, judges, we did pay the $18,000 anyway, so we're not real bad guys here. But logically, there cannot be waiver or estoppel, is your argument.
Well, right. I mean, essentially, because there is no standing, basically the whole case crumbles. When Apex, if Apex has an assignment that's not valid, under the cases from the 4th District, and there are some other cases under the same statute, but with different reasons, not related to the estimate. But all these cases that come out that have said that an AOB company can't sue for breach of contract, then how could that same type of AOB company then come in and sue for bad faith, for excess damages, if they can't even sue for a breach of contract?
Well, their argument is 624-155 says any person, which is different. What's your response to that?
Any person with standing.
It says
They have to, they brought the case
Where
as an
does that
SME.
say that in the statute?
I'm sorry?
Where is standing referenced in 624-155? I mean, that's their point, is that this standing discussion about the AOB, that's one thing. That has to do with if you had filed a deck action to determine, or someone had filed a deck action, if they'd filed a deck action to determine the validity of the AOB. But they've not sued under the AOB. They've sued saying that they have suffered damage because of the conduct of USAA. They've laid out a little bit of it. They've sketched it out vaguely. But they're saying that the insurer has caused damage to a person by its conduct in certain ways. And they've outlined that. They've set it out in the complaint, and the statute covers that. It doesn't speak in terms of standing other than to say that anybody that suffers damage at the hands of an insurer from its conduct, as enumerated, can sue. So it's begging the question almost, it seems.
But they sued as an assignee. So
They sued
have,
because they were an assignee. That's how the story started. This story started because they thought they were an assignee, and they came to USAA as an assignee, at least in their mind. And USAA acted in certain ways and conducted itself for 2 years in a certain way towards Apex. And they say that because of that conduct, they suffered damage. So yes, the AOB or the assignee status is the beginning of the story, but it doesn't strike me as the middle or end of the story.
I would disagree respectfully, Your Honor. They filed the CRN. It's on page 42 through 45 of the record. There are 2 boxes on the CRN on the first page. One says complainant and one says insured. And in both boxes, they chose to write Apex Roofing and Restoration, LLC, as assignee of Monica Williams, in both boxes. Then they file their complaint and their amended complaint as an assignee, Apex Roofing and Restoration, LLC, as assignee of Monica Williams. As an assignee, they have to have a valid assignment. So I don't know how they can get around that.
But maybe if USAA had mentioned sometime in the 2 years that it was dealing with Apex, hey, we don't think you're the assignee, then maybe Apex could have said, oh, well, this is news to us. Now we've incurred damage because you've led us down this road for the 2 years. We're going to check the box on the CRN that says we're the complainant instead. But in their mind, when they filed the CRN, because they had no notice from USAA that they were otherwise, they checked the assignee box.
But that's shifting the burden to USAA. There is nothing in
You
this.
moved to dismiss. It is, of course, the burden is on the defendant.
There is nothing in 624.155 that requires the insurance company to file a response to the CRN. There is a penalty that if they don't file their response, then there's a presumption of bad faith. However, there's no requirement that a response must be filed. And so then if no response is required to be filed, then how can USAA be penalized for filing a response that might not include all of the legal defenses that it might have? And the issue at the complaint stage, at the litigation stage, is standing. And so regardless of the fact that USAA didn't tell them in the CRN response or at any time during the claims process, the fact is that here we are in a lawsuit and they don't have standing. And
If Exhibit A, because I promised I'd ask the same question on both sides. So if Exhibit A had July 20th across the board on both documents, is there a motion to dismiss that you could file? Is it the same motion?
not based on an invalid AOB. However, there is no case law in Florida. There's nothing cited by the appellant, and we have not found any appellate decisions that allow for a first-party bad faith case based on an assignment of benefits. The cases that we've seen are all filed by an insured and not by an assignee. And so it's our position that there's nothing that would allow for the bad faith case filed as a first party.
Sure, but on the one issue that the trial judge granted the motion to dismiss on, which was the invalid AOB, had there been July 20th on both documents, then that argument's not made by USAA and the trial judge is not granting that motion on that basis? Is that?
Not on the invalidity of the AOB, that's correct.
So basically, this comes down to, this whole case, like the dismissal comes down to, they're not entitled to go forward with a complaint challenging the conduct of USAA because of a difference of 1 day in a date on those two documents. They can't prove, they're not entitled to go forward and to present evidence as to what happened on those two documents to make out whether that is a valid contract, or, what those conversations were, who relied on them, what happened between USAA and Apex after that for 2 years. They're not entitled to present evidence on any of that because of a difference of 1 day?
Based on the statute and based on the purpose of the statute, I would say that is correct, and the other district court cases that have found that where the estimate was provided after the execution of the assignment, the assignments are deemed invalid and unenforceable.
Did any of those cases address the concept that goes back maybe 100 years, the concept that multiple writings can evidence a contract? Like if there are multiple writings that can be read consistently, that you're required to read them all together as one contract? Did any of those Kidwell cases address that?
I don't believe they did, Your Honor. But as I said, there are other cases that are not related to a late estimate that also find strict compliance with 627.7152, and when there is no strict compliance, then the assignment is deemed invalid. One more point that I want to bring up, I see that I'm short on time, that we've cited to some cases in our brief about where an insurance company participates in the appraisal process, their coverage defenses are not waived. And so I would liken that to this situation as well. We participated with them in good faith in order to get this claim adjusted. Apex invoked the appraisal process. We participated with them in that. We paid the appraisal amount, and based on that, and based on that case law, that we would say that we should not be held to a different standard, that we're still entitled to go forward with a standing defense once the lawsuit was filed. And we would ask that, one more thing, also the trial court didn't rule on these issues, and so as we argued in our brief, it would be improper for this court to rule on them when the trial court didn't. We would ask that the court affirm the order granting the motion to dismiss. Thank you.
Thank you.
First, just kind of to go backwards a little bit, standing is not a coverage defense. So while going to appraisal doesn't waive your right to raise, that's not covered by our policy, even though the appraiser said it was included. Standing is not a coverage defense, that's who has right to be where. As to the argument that the statute doesn't require a response, USAA in their brief responded, specifically pointing out that the Imhoff case from the Florida Supreme Court is what created, is what they said, the requirement that a CRN have a response filed by the carrier. The explanation of the Florida Supreme Court kind of goes to why the necessity of raising the defects in the CRN response are a matter of equity and why the common law principles of waiver apply. The Florida Supreme Court held, we note that when an insurer does not respond to a civil remedy notice within 60 days, the insurer flouts the very purpose of 624.155. The purpose of the statute is to tell the insurers of this state, you're doing something that the people who are insured by you or who are negotiating and dealing with you in good faith, in our case, believing themselves to be standing in the shoes of the insured, are telling you there's something you've done wrong and it's giving you a chance to fix it because you have an affirmative obligation placed on you by the legislature to behave in good faith. And part of good faith is coming with clean hands to a conversation. If I can briefly just point out, one of the things that's been brought up several times, Judge Thomas, to your point about what was and was not addressed and what we did and did not argue, this court has a de novo review. If the court finds that the waiver and estoppel arguments were not properly ruled on by the trial court when they should have been, the proper remedy is to reverse with instructions that she consider those, and if we end up back here again before you so that it's properly preserved, so be it. If this court finds that based on the arguments that were made when we were the plaintiff at the trial court below, again, the reason that we did not raise the issue of the validity of the assignment on appeal was not because we think it is correctly applied, it's because the fourth DCA cases were binding on the trial court, even though they clearly are not, as a sister circuit, binding on this court if you wish to make a different conclusion. But we were trying to make the arguments that based on the clear facts of this case, which in the complaint we do allege specifically in the amended complaint, that we relied on the conduct of USAA throughout the claims process, not limited to their response to the CRN, in which the first time they referenced the assignment, and I quote, USAA received the assignment of benefits from Apex.
All right, your opposing counsel was in strict compliance with the time frame, so
Yes, Your Honor.
I'll ask you to do the same.
Yes, Your Honor.
Thank you both for your arguments. Court's in recess.
Thank you for your time.
All rise.